My name is John Morrison with the Institute for Human Rights and Business, and it's a privilege to be here to moderate this session. I'll say a few words and then we will go to our three speakers who have 7 minutes each, and then our two respondents who each have 5, and then we get into the question and answer routine. I think you're all familiar with that by now, but there are 3 microphones, civil society, etc. there, states here, and there'll be a long queue behind the business microphone on the left-hand side, I'm sure. And people should move to the end of the rows when we get into the discussion period to show me that you're wanting to ask a question. Employment and recruitment agencies. I would say in opening, this is a business sector which is relatively new to the business and human rights world. I think there have been many more discussions in the other house up the hill on this issue, particularly around the context of ILO Convention 181 and things related to that. But if we think about employment and recruitment agencies, actually perhaps it's one of those business sectors that has the biggest impact on human rights globally. If we think about internal migration in large countries like China, the US or India, cross-border migration and migration flows from many parts of the world, such as from South Asia to the Gulf, from South Asia and Eastern Europe into Western Europe, from Central and South America into North America, etc. There are many types of migratory flow. And increasingly, in most countries around the world now, a sector which I think was largely state-controlled, state-owned in certain periods of history is more and more within the realms of the private sector to marry up the people with the jobs. Now, when that works well, I think it works very well. But we will hear from Siat on the right-hand side a bit later. I think something that's quite unique in this space is that when I hear the business association in this area, they actually call for more regulation. I mean, how many other panels have you been to in the past 2 days where the business representative will call for more regulation? Not so many? Okay, well, this is one where I don't want to put words in your mouth, but you might say that. But I've heard that before. So that itself is interesting. Of course, there's a difference between employment and recruitment agencies. With employment agencies, the labour service provider retains fully or partly the employment relationship with the worker. Recruitment agencies are more about moving a worker from point A to point B, where the employment agency is then handed over to the permanent employer. Now, we don't have a trade union on the panel, but I know a particular area of concern for trade unionists is particularly around the employment agency side, particularly temporary agencies and the so-called triangulation of the employer-employee relationship, where it's sometimes not always clear who has the primary responsibility for protecting the rights of, well, respecting the rights of the employee, whether it's the agency itself or whether it's the user enterprise, as we say. That's one issue that I'm sure we will come back to. We had the privilege, Rachel and I and others, and many people on this panel inputted to it to do a guidance document for the European Commission on employment and recruitment agencies. I'm sure Rachel will mention it in her own intervention. Copies of it are online. But it was a very useful exercise for us to begin to flush out what some of the areas of good practice are and what some of the inherent vulnerabilities for migrant workers are. Now, the previous panel here, I think, discussed some of these as well. But issues obviously like passport retention, prepayment by workers to the agency, sometimes creates contexts of vulnerability. for migrant workers. At the worst end of that spectrum are issues like trafficking and forced labour. And the previous panel talked about that. But along that continuum are various degrees of labour exploitation. And so I think the panel will talk about indicators of vulnerability and what can be done to prevent workers moving, particularly cross borders, from being exploited by employees at the end of the process. I think particularly of workers in the construction or agriculture sectors, and especially domestic workers, as particularly vulnerable groups of workers in that context. So I'll stop there. We'll get into the discussion, and I'm sure you'll all have plenty of ideas and thoughts to share. Our first speaker then is Nick Forster, not Tristan Forster, your brother. There's two of them. They look very similar. We have Nick today, but we could have had Tristan, but we have Nick. FSI Worldwide, based in Qatar, Abu Dhabi, Dubai, is a relatively unique model as a recruitment agency that claims to be ethical, that claims to have a model that avoids many of the traps that I began to lay out at the beginning. So let's go straight to you, Nick, and please make your opening comments. Thank you.
Thanks, John. Pleasure to be here today. We were recently in Abu Dhabi together at the Global Business Initiative. I'm the co-founder of FSI Worldwide. My brother and I set it up in 2006. And we are quite an unusual beast out there in as much as we are an ethical recruitment company who is recruiting out of a number of the largest labour exporting countries in the world. We've developed a model which is unusual out there because the traditional model that exists in all of these labour exporting countries is a model that is a commercial model based around charging fees to candidates. The traditional recruitment model that persists across all the labour exporting countries is one that has been around for a long time. And there are two things that these organizations, which are often very big, powerful, far-reaching organizations, there are two things that they're extremely good at. One is creating opportunity to extract fees from migrant workers. And the second thing is convincing big companies that they're not doing that. So what I always say to business and government is we've been on the ground, we've set up infrastructure from grassroots in a lot of these countries, starting in Nepal, because we were seeing our former ex-Gurkha soldiers getting exploited by manpower companies, extracting fees, etc., debt bondage situations, retention of passports, all the things that we're all very familiar with, and decided that what we needed to do is set up infrastructure there to protect the guys from that. It's one of those things that we thought, well, this should be fairly straightforward. Actually, it took us a long time and a steep learning curve to realize just how deeply rooted in the societies this traditional model of labour recruitment is. And it took us time to really establish ourselves, and we realized very quickly that what we needed to do is establish something ourselves literally from the bottom up. And the only way to police out this traditional model was to put key things in place at different times, take people out of the decision process who could be influenced by family or friends, and to start to change the very nature of the way people thought in these countries, which was that unless I'm paying for something, it has no intrinsic value. When I set up our office in Kenya, we were recruiting for a large US government contract, great terms and conditions. We were going out to the villages and nobody was coming forward. And my question to Brigadier Richard Onyango, who was a wonderful character who was helping us put all this together, was, why is no one coming forward? And he put his big hand on my shoulder and he said, because they don't believe you. And the point was that they thought these strange people that had come here to give them jobs and who weren't charging any money for it was all a big scam. It was more a case of I'd rather pay for something to these shady brokers, because at least then I have a feeling that there is some value to it. So a lot of things, we've had to work long and hard over the last 10 years to change the way people think in the labour source countries. We have set up a model called EMP, or Ethical Manpower Provision. We define it as the recruitment and deployment of workers protected from these traditional models that I've been talking about in the labour exporting countries, which too often result in the economic death of migrant workers. Our model ensures that at no point do the workers have to pay any money for their job, even when there is provision within law in some of these countries for payments to be made. Because the problem is, the second that somebody starts taking money from someone else for a job, it opens the floodgates to everybody wanting a piece of the pie. We've worked very closely with the IOM, the ILO, friends here today who've done some great work in the area of protecting migrant workers and understanding what the real issues are. What can business and what can government do? Well, first off, business can educate themselves as to what the real issues are on the ground. I know a lot of companies who have great CSR programs. They've invested a lot of time and money in trying to ensure that their labour supply chains are clean of workers in debt bondage and fee payment, and they're convinced they're there, and the reality is that they're far from it. Until you're on the ground with the local expertise, knowledge, cultural understanding of how these embedded networks work that have existed forever, you need to start from the point of what I say to people is leave room for doubt. If you can be convinced that actually your labour supply chain is not clean, then you're probably starting from a good point. What can government do? Well, these sort of discussions, understanding the issues, getting behind it with unilateral policy and coherence, but I believe that it will ultimately be driven by business. And one of the things that we're working to demonstrate to big business is that, in fact, ethical recruitment, ensuring that none of your workers have paid and haven't come through this traditional standard model, will actually result in bottom line commercial benefits for you. What makes business change its mind? It's margins and its bottom line. So if we can demonstrate through our pilot projects to construction sector business and other sectors that in fact ethical recruitment makes commercial sense for them, then people really will start listening. And we believe this is very much the case. And I don't have time to go into why today, but it's certainly something that we will be sharing that information on because it's critical. Then it's about government backing the good work that's being done by organisations like the IMM and ILO, so that we can work together and drive that change and start to change the way that these recruitment companies operate in the labour source countries by big business saying, we don't want to work with you anymore because you're following the traditional model and actually that's impacting on my bottom line, as well as it being unethical and not in line with our CSR policies. This is a massive subject. This forum is a great opportunity to have these discussions. I was at the UN high-level dialogue in New York a couple of months back as well, and it's really good to see these issues finally gaining the public profile that they need to. Thanks very much.
Thank you, Nick. Thank you also for reminding us some of the specifics of the sort of private security sector as a very specific area of labour recruitment. You mentioned Kenya, for example. There is draft legislation, I believe, soon before the Kenyan Parliament to talk about the whole idea of armed private security. Most countries in Africa don't have armed private security, but recent events in Kenya and some other parts of East Africa have prompted this. It's also one of the areas where governments themselves have come together with the Montreux Agreement for private security companies and the International Code of Conduct for private security companies, which is a public procurement requirement now for some states and seems to be gathering some momentum. So I'm sure we'll come back to those kind of issues maybe in Q&A. Thank you very much for that. The next speaker is Juliette de Rivero from Human Rights Watch. Where are you, Juliette? Oh, you're down there. The floor is yours, Juliette. Thank you.
Thank you very much for the opportunity to contribute to this panel. We're very pleased to be here. Human Rights Watch has done numerous investigations on the abuse of migrant workers, particularly in the past 10 years. We've done several in-depth reports and recommendations based on our research, and our focus has been mainly on the situation of migrant domestic workers and also construction workers who are migrating either within Asia or between Asia and the Middle East. The countries that we've looked into include Sri Lanka, Indonesia, Philippines, Cambodia, Malaysia, Singapore, Thailand, Bahrain, Qatar, United Arab Emirates, Saudi Arabia, Kuwait, Lebanon, and Jordan. And indirectly, we've documented, of course, abuses of Indian, Bangladeshi, and Nepali workers in some of those countries. So what are the kinds of abuses that we have been documenting? What we've seen is that there is a very wide range of employment agencies. There are registered agencies, unregistered ones, some focusing on some aspects of recruitment, some trying to cover the whole breadth of the employment cycle. There is a great diversity, but there is also an entrenched and deeply rooted, as you said, system of abuse in many of these employment agencies. A lot of it is connected to the commissions and the fees that are charged from people that are recruited. But the exploitation is not just about that. We've come across recruiters who try to do their work ethically, and we have found that in general it's poor regulation and monitoring and enforcement mechanisms that allow those that are engaging in exploitation to flourish at all stages of the recruitment and the placement phases. So what do some of the problems that we've seen look like? In the home countries, what we see is these agencies or agents misleading the people they're trying to recruit by providing them either incomplete or deceptive information about the migration process, about the terms of their employment, or even their work contract, about the amount of wages, the type of work they will do, and even in some cases the country that they will be sent to. We've often seen the situation where fraudulent documents are created, in some cases to make somebody appear as older so that they can recruit children. We've seen workers being trained in confined areas, sometimes confined for weeks or months, and in overcrowded and situations of health risks. In the home and the employment countries, we've documented extensive cases of physical abuse, sexual harassment, particularly for migrant domestic workers. The whole issue of controlling the worker's identity and travel documents. And then, invasion in the worker's privacy by HIV tests, pregnancy tests, and other requirements that sometimes are obtained without full knowledge or consent. In the employment countries, we've seen cases of contract substitution, so giving a worker a different contract once they arrive at their destination. Placement with employers that have a known history of abuse and that haven't been sanctioned for it. And then the whole situation of extracting fees from the first salaries that workers are receiving. In some cases, we've seen workers that especially domestic workers, that are paying up to 9 months of their salaries to cover the recruitment fees. So they only start receiving a real salary the 10th month after working, which is really incredible. One of the biggest problems that we see is the lack of complaint mechanism or readily available channels for workers to file complaints or to be able to claim their rights. Often if they try to complain, their rights are further exposed or they are further abused by their employers. For us, the solution to these situations is really grounded in more regulation. A lot of this happens because of the gaps in the legislation, especially for domestic workers. Domestic work often isn't regulated by labor laws, and therefore they are excluded from all labor protections in many countries. But also regulation of the recruitment agencies themselves. Many of them are only regulated in the most minimum and basic way, requiring them some kind of financial deposit to be able to operate, but nothing to control the standards they observe, or nothing to sanction the abuses that they commit. We think it's important for governments to also allow the non-governmental sector a space in this area. Often migrant workers that are victims of abuse connected to recruitment feel more ready to report their complaints to NGOs, and NGOs have a sense of the environment that they are working in, and therefore allowing NGOs to play a role within the system of protection is something that we think would be advisable. There's a lot of talk about good practices. In this particular area, we feel that the good practices are pretty weak. There have been, for instance, some agreements between countries. There's recently been one between Malaysia and Indonesia, or between the Philippines and Saudi Arabia. But often these agreements are not integrated into law and do not have proper enforcement mechanisms, or remain very vague in terms of the controls and the obligations that they present. So we're concerned that a system that only focuses on the goodwill of businesses to do the right thing, and where governments obviously are not enforcing human rights in the way that they should do, actually requires stronger regulations, stronger obligations at all levels for the government and for the business sector, and stronger protections for the people that are vulnerable. And this sector, I think, is particularly important to develop these protections, because we're talking about a very vulnerable population that is being recruited, that is very vulnerable to exploitation and abuse. Thank you.
Juliette, thank you, and thank you for so eloquently setting out a lot of the inherent vulnerabilities of this process. Now, our next main speaker is Fred van Haasteren. I hope I pronounced that right, Fred. Yeah, I did. From the International Confederation of Private Employment Services International Confederation of Private Employment Services Federation. Is that right?
I will tell it.
Yeah, I call you guys CIET anyway. So, okay. Fred, it sounds like there's a bit of consensus emerging on the panel. So, are we all going to be in violent agreement? To be quite boring if we are. So,
okay. I will do my best. So, well, ladies and gentlemen, good morning. My name is Fred van Haasteren, and I'm representing here the CIET, C-I-E-T-T, and CIET stands for the Confederation Internationale des Entreprises de Travail Temporaire. It's the International Confederation of the Private Employment Agencies. And this body is representing the interests of private employment agencies worldwide, or as you see here, the recruitment and agencies industry. That's the terminology which is used here. We were founded in 67 of the last century, and we consist in the meantime of nearly 50 national federations of private employment agencies and 6 of the largest companies worldwide. And that means the brands Adecco, Randstad, Manpower, Kelly Services, GI Group, and USG People, all multinationals in this field. I've been working in this industry for more than 30 years for Randstad, and since 2 years I've been the president of Shed. Shed has around 30 European members and more than 20 members outside Europe, and we represent 120,000 private employment agencies employing more than 10 million people during the day. As we have discussed over the last days, the UN guiding principles are based on 3 main pillars: the duty to protect, respect and remedy. That's what you all know. It's very important to look at these 3 pillars together in a holistic way. They have to be implemented together in order to be effective. But today I would like to focus on the first pillar, because our industry needs to have appropriate regulation as a prerequisite for them to ensure respect of human rights in their business operations. In our industry, we are particularly sensitive to human rights because our business is people. Our daily job is finding employment for people, helping them out of unemployment and into a productive and fulfilling life. We also work with companies, providing them with the right talent to innovate and succeed. However, in order to make a successful match between labor demand and supply, we must guarantee high quality standards for workers and for companies. These quality standards can exist if there is appropriate regulation on our industry. In several countries there is no appropriate regulations for the sector, which means that there is no way to distinguish bona fide employment and recruitment agencies from the rogue operators that take advantage of the legal vacuum to make profit at the expenses of workers. For Shed, the first step to ensure the sound implementation of the UN guiding principles is to put in place an appropriate regulatory framework for our industry. And by appropriate regulation, and John was saying it already, I mean that it's based on ILO Convention on Private Employment Agencies of 1979. It's number 181, which strikes a balance between protection of agency workers and the creation of a regulatory environment that enables the development of the industry. I just quote here 2 components, and you have heard that already here, that contribute to this balance. First is the prohibition to charge fees to workers, and second, the establishment of licensing or registration systems that can filter out the malafide operators. In this convention, there is more safeguarded. There is also safeguarded the freedom of association and collective bargaining, the equal treatment, no child labor. There are guarantees for complaint procedures. On several elements you see worker protection, which is safeguarded in this convention. So everything is reflected already half of the 90s, and you see that anchored in this very good convention. Several countries around the world have not yet adopted regulation on our industry, and in these countries Shed and its members rely on the Shed Code of Conduct. The Shed Code of Conduct ensures that the protection of workers remains at the heart of all the activities of Shed members. For example, our members strictly adhere to the prohibition, and then you hear it again, of fee charging, even when they operate in countries where it's a common practice, like for instance in India and Nepal. The code is going along the elements of Convention 181, so you see all those elements reflected in our Code of Conduct. When no specific regulation is in place, our members still apply the Shed Code of Conduct, which ensures that the business remains clean and in full respect of the fundamental principles and rights at work. Beyond this, Shed is also engaged in several voluntary initiatives that aim at fighting abuses that are sometimes associated with the industry. For example, Shed members fully endorse the ethical principles against human trafficking. We are also involved. We were involved in the DACA principles, and several Shed corporate members have signed the UN Global Compact, which focuses on human and labor rights, environment, and anti-corruption. Despite our desire and core mission to fully respect the rights throughout throughout our operations through our code of conduct and our engagement to various initiatives, it's not sustainable to rely solely on self-regulation. Yesterday in one of the panels, Professor Siglic, he was already pleading for also binding rules, and we can agree with that, because we need also binding rules. Apart from voluntary codes, we need also binding rules, and the framework is set in Convention 181. That's the cornerstone for our industry to guarantee high quality services to workers and companies in full respect of the fundamental principles and rights at work. So far, 27 countries have ratified Convention 181. It's often said that there's not a lot of countries, but if you look at the last 20 years and all the conventions which were developed by the ILO, it's ranking number 4, so it belongs to the most ratified technical conventions since 1990. Business is ready to take on this responsibility, and SHED members already do so, but I would like to point out that small and medium-sized agencies may face additional challenges in implementing the guiding principles compared to big multinational enterprises. Therefore, it's important to appreciate that small and medium-sized companies may need additional guidance that can help them in implementation of the guiding principles. And in this context, it was already said, here is the leaflet. You can find it upstairs on one of the tables. It's about the sector guide which was developed by the European Commission's the sector guidance for the implementation of the UN guiding principles in the employment and agency sector, prepared by John's Institute and Rachel's Shift. The guide is a very good tool that talks concretely to employment and recruitment agencies about how they can incorporate the guiding principles into their operations and provide cases and examples that are practical and relevant for the big multinational companies, but also for the small and medium-sized. And I would like to conclude by reiterating my invitation to governments to ratify ILO Convention 181 to set and enforce the appropriate regulatory framework for the employment and recruitment agency sector. We see it as a precondition that enables the industry to take its responsibility to respect. Without it, we have to rely on self-regulation. In the case of SHED, self-regulation consists of its code of conduct, which covers its members and cannot extend to all other actors that operate unethically. So we need a level playing field, and codes and voluntary initiatives are okay, but we need more. We need also real binding rules. Thank you.
Thank you, Fred, and probably the only business association over the past 2 days that is in alignment with Professor Stiglitz, which is great. I mean, we've got too much consensus on this panel, so we're relying on our respondents to shake us up a little bit in the audience. I mean, my colleague's just gone to get the flyers of the European Commission reports, so we'll distribute those in the room in the next few minutes, and you'll be able to download the recruitment agency guidance, which Fred talked about, and I'm sure Rachel will talk about in a few minutes. I just want to challenge us a little bit. We're just about to go to the two respondents. I mean, the perspective that we haven't had from this panel is the user enterprise perspective. I would say that every single multinational company has temporary workers somewhere in its supply chain. Third-party labour providers are in every supply chain of just, I would say, of every company that's here, with maybe one or two exceptions. And particularly in some geographies, in some parts of the world, etc., that might actually be one of the most significant human rights risk areas when companies do their due diligence. And I think companies are only beginning to wake up now in the apparel sector and some other sectors as to the significance of that risk. And you mentioned the Dakar Principles for Migration with Dignity that we worked on 3 years ago with the government of Bangladesh and a lot of stakeholders in Bangladesh to try and elucidate those risks for the user enterprise, for the multinationals that actually contract with third-party labour providers as a supply chain issue. So there's a sort of complexity to that perhaps we haven't reflected from the panel. So I'm going to go now to Felipe Burgueño from the Center for Labor Reflection and Action, CERIAL, based in Mexico. Señor, sigue.
Thank you very much, and apologize in advance. I will do my presentation in Spanish. Bueno, es muy bueno conocer.
It's very positive to see how we have very good initiatives by the agencies, employment agencies, to face the problems we have. In a particular case of Mexico, in general, workers don't have to pay any fees to have a job. However, during their contract, they never receive the same benefits as a permanent employee. For us, it is a big responsibility. We think it's a big responsibility for companies to adopt policies of respect to human rights independently of the regulations that the government may have and that the law might or might not have. In the case of Mexico, we have a very strong law that protects workers against these abuses. However, there were still abuses within these agencies. The government has currently changed this law to facilitate the work of these type of agencies, which has gone in detriment of the benefits that the workers already had. Regarding migrant workers in Mexico, specifically in the agricultural service and domestic workers area, they have been affected very much in their human rights to the point of reaching slavery. We had a very specific case a couple of months ago of a company, an agricultural company that had slaves in Jalisco. As we said, medium and large companies need to have certain regulations and apply these principles in practice. But it is also important that multinational corporations have guidelines that are clear and clear policies on how to apply these guidelines. In our report of this year, we documented a case about employment agencies where they don't even, workers don't even have access to their contracts, to their work contracts. Last week, we were researching in Reynosa and in Monterrey, which are located in the border of Mexico, where there are many factories. And we realized that things, in spite of all the work that has been done, things have not changed. I'm not sure that they're not carrying out any pregnancy tests for women, or they're not taking into account sexual preferences, etc. So there are even some companies that are giving out, instead of giving out short contracts, are giving out just one indefinite contract as an agency worker, but they are in reality working in the factories. This is not an advantage for the worker, because it's still in a disadvantage in relationship to the other workers that do the same work.
Contratado o incluso un contratador.
So when a worker is hired and the employee or the employee wants to complain about an abuse or a violation of his rights, it is very difficult for him or her to have a good result, because there is a power game involved in regards to the company, which puts employees in a disadvantage, because there are no channels of complaint in an equal way. They don't have access to documents such as their contracts, which by law they should have a copy of. In this sense, while these practices are still voluntary, And while they do not have a serious conviction to respect human rights, these violations and these regulations will remain insufficient. Thank you.
Okay, and so the second commentator is Rachel Davis from Shift. While Rachel's speaking, if there are any of you that want to come in with questions, you could begin to shuffle your way down towards the microphone, subtly. Yes. If you can do it subtly, please do so. Rachel.
Thanks, John. Thank you all. I'm going to talk a little bit about some of the learnings from the European Commission guidance that's been mentioned that Shift and the Institute worked on together. I just wanted to note that in addition to the others who aren't on the panel today, we don't have a state on the panel today. And so I hope very much that we get some questions from states in the audience. We know from the EC guidance process, which was a comprehensive multi-stakeholder process over 18 months, that the risk of potential negative impacts for agency workers can increase in certain situations. And these include where there are more broadly poor or no protections of workers' human rights in national law, where workers lack awareness of their rights, where agency workers cannot join a trade union within the user enterprise, and they lack equivalent representation or collective bargaining power within the agency itself. And we know that there are special vulnerabilities for migrant workers, and we've heard about those. In the EU, of course, the Temporary Agency Worker Directive is very important. There's also a tradition of social dialogue. There are some strong trade unions. But what we saw in the EC guide is that, of course, as many of you will know, problems still exist in the EU. And very often this can come from the demands of clients and from user enterprises that are placed on agencies. There's also an opportunity for agencies, and the guiding principles highlight this, which is if you are an agency operating in the EU under robust protection of workers' rights, of agency workers' rights, there is no bar to you extending the same practices that you have into other jurisdictions where national law may be lower or there may be less protections, and the guiding principles make that clear. A few points about implementation of the responsibility to respect. When we look at agency policy commitments, we see now a basic expectation that these will include commitments not to charge fees and not to retain identity documents. Beyond this, there are some really promising approaches, including commitments not to replace striking workers or otherwise undermine the freedom of association of workers in user enterprises in particular that some companies have adopted. When it comes to due diligence, there's a real importance in this sector for effective due diligence on business partners. Here we're seeing agencies start to look more closely beyond the policies that either their other agency partners or the user enterprises or clients that they are engaging with have on paper, and instead really dig into what will the worker take home in their pocket. What are the actual conditions in the workplace? Very often supported by in-person visits or other verification with the assistance of trade unions where they exist. We heard a lot, and Frank mentioned the issue of SMEs in this sector. There are increasingly, I think, lists of questions, good questions, that agencies can ask, and SMEs can ask these, even if they don't have the capacity to conduct in-person visits, for example. They can ask them of their business partners, and you can tell from your business partner's reaction how seriously they're taking these issues. So there are things that SMEs can do, and I think the guidance helps with that. We see some good development of internal systems within agencies to test the effectiveness of their internal training and policies on this, and a potential role for them to play, and we've heard this a bit from Nick, as advisors to user enterprises, almost making the business case, right? Why it makes sense to ethically recruit, why it's a really bad idea to make discriminatory requests, if not illegal, and certainly in violation of human rights law. So this kind of role that agencies can potentially play. When it comes to grievance mechanisms, here I think is perhaps one of the weakest areas, and Felipe's comments reflect that. There's where you have legitimate trade unions, the guiding principles recognise that they can very often be the most effective grievance mechanism possible. Where they don't exist, where that's not possible, this really becomes challenging, as you all know. What we explored in the guidance was the need for agencies both to have their own grievance mechanisms to ensure that the workers that they employ have access to that, but also to consider access to the user enterprise's own mechanisms wherever that's possible, because grievance mechanisms should address grievances as close to the source of the grievance as is feasible. What they then need to do is work out who has responsibility between the agency and the user enterprise for informing workers about where they can go to complain, where they can go to raise concerns. We're also seeing some creative state approaches when it comes to thinking about remediation for migrant workers, which is really something where you need the state to be playing its role, and we can talk about that in questions. So finally, I would just say that this is an area where businesses are asking for more regulation. As John said, that's unusual. There is also a lot of emerging practice amongst companies themselves which could be strengthened and broadened, and we hope that the EC guidance will contribute to that at the same time as strengthening the need for further regulation.
Thank you, Rachel, and Rachel and Felipe, thank you to you both for beginning, I think, to really get into some of the problems that exist. When looked at globally, we at the Institute think this is actually one of the biggest business and human rights challenges that exists in the world. And I guess what we get here is the perspective of solutions and the good guys in a way. But looked at globally, it's clear. I mean, and it's not just a global South issue. In my own country, the UK, 23 Chinese workers were drowned in Morecambe Bay picking shells about 10 years ago now. And that was a completely unregulated third-party labour provider, a gangmaster involved. That led to regulation, licensing scheme for the agriculture sector in the UK, which has not been extended to construction or to catering or hotels or any other sectors where there's some evidence, I would say, some good evidence of worker vulnerability in London, right? So this is omnipresent. I would say there are vulnerable migrant workers probably within several hundred meters of where we're sitting today. And it exists in every country, and not always, but often, third-party labour provision, particularly I would say the bottom end of the tank, the less scrupulous end, are there to exploit workers and arguably also exploit the businesses concerned too. So thank you very much to the panel. I think we've really got off to a very good start. Can you, I'm tempted to allow you to stay where you sit and ask the questions, but I might get in trouble with the United Nations if I do that. Can I change the rules? I can go for it. Okay, I have permission to allow you to stay where you are, but could you introduce yourselves and say your province, and that will allow me at least to get some balance. So I'll start with the two gentlemen here, and then we'll go to Richard, and then I'll go back, and then I'll come across. Right, sir.
Thank you very much. I'd like to extend our appreciation to the moderator, the distinguished panelists, and the commentators. My name is Khalid Al Thani. I'm the director of the Bureau of Human Rights, State of Qatar, and I'd like to share with you the State of Qatar's experience. We're going through a distinct phase in its development and making rapid strides toward full and comprehensive development. Qatar Vision 2030 and the National Development Strategy 2011-2016 provide the roadmap and the framework for this comprehensive development. In the Human Capital Report 2013, which published by the World Economic Forum, Qatar ranks as the first country in the Middle East and North Africa, and number 18 among 122 countries covered by the report. The 4 pillars of the report are health, education, the workforce, and employment, and the enabling environment. We consider the promotion and protection of human rights in the employment and recruitment sector as a strategic option for its comprehensive reform policy. This has been clearly indicated on Qatar Vision 2030 and the National Development Strategy 2011 and 2016. Qatar has made considerable legislative, institutional, policy and capacity building efforts to protect human rights in the employment and recruitment sector. Both Qatar Foundation mandatory standards of migrant workers' welfare for the contractors and the subcontractors in workforce charter adopted by the Qatar World Cup 2022 Supreme Committee can be cited as example. The state has signed a number of bilateral agreements with countries of origin regulating the employment and recruitment process, as well as guaranteeing the rights of expatriate workers. Recently, Qatar has engaged in an e-project with sending countries, aiming at strengthening the recruitment process. Qatar's commitment to further improve and strengthen the human rights of its expatriate worker is a strategic option, since we believe that the expatriate workers are great contributors and partners to the country's economic and social and cultural development. Thank you.
So there's a gentleman there, and then we'll go to Richard Howard.
Thank you very much. Is it working? My name is Marco Ferri. I'm from the European Union delegation. I wanted to say something about the European Commission guidelines, but you have stolen my work. So I will ask a question, and that's on a personal basis, in order to stimulate the debate. I have heard the business need for regulation and the call for the ratification of Convention 181, which is the ILO Convention on Private Employment Agencies. You must know that the European Union supports the ratification and implementation of up-to-date conventions, so including 181. However, the Director General of the ILO, in his report to the conference this year in 2013, he has recognized that this convention in particular is one of those with a very modest level of ratification, and it is surrounded by a lot of controversy. And the fact that there are only 27 states ratifying, it's a signal of this controversy. So I ask the panelists, in particular the person from SIET, Mr. Fred van Haasteren, how can you fill this gap? So there is a gap between the fact that there is an international instrument dealing with private employment agencies and the fact that it is not ratified because there is a controversy around the content of this convention. There's a gap to be filled. I would like to know from the panelists how this can be done. Thank you very much.
Thank you very much, and we'll take a few questions. I'm going to go to Richard, then I'll go to Anne, but we'll take a few, and then we'll let the panel come back. Reminds me also that the ILO Convention on Migrant Workers and Their Families is also not ratified by no EU member states. I believe the only European countries are Bosnia and Turkey that have ratified that. So that's another piece of complexity. Richard Howard, member of the European Parliament.
From the European Union institutions, I'm very pleased to be following Marco as well. 3 questions. One is to our friend from Human Rights Watch and also to the International Federation. Using this area as a case study for implementation of the guiding principles, it seems to me that this is very interesting because it's not about abuses taking place in developing countries or fragile states or conflict states with companies responsible somewhere in their supply chain in developed countries, including in Europe. It's often migrant workers from developing and weaker states having their human rights abused within the European borders and within developed countries, and where there is the possibility of really creating a partnership with the developing countries in the UN to be a bit humble and a bit self-critical about our own failings. And I wonder if Human Rights Watch and the International Federation can comment about, this as a case example of the guiding principles in that respect. And I think what the football federations have done over Qatar, I know it's been very difficult for the colleagues from Qatar, have done, has really put international attention onto this issue. Secondly, I would never accuse Rachel of stealing anything. which seems to me to be an abuse of some kind or another. But I want to place on record our thanks for what you've done to help the European Union shift us done in relation to the various guidelines that you brought forward. And just to make the point that these guidelines have been consulted worldwide. They're not just European instruments. They're instruments that we've tried to contribute to the worldwide debate on implementation of the guiding principles. And I'd like to draw attention to the fact that in the guidelines you helped us produce, that you talk about the fact that migrants are frightened to complain and claim their rights because they might lose their immigration status. And in my own region of the UK, where I represent, agricultural workers working in the fens from Asian and Eastern European countries are often in that position, and it's a very important point. Also in relation to charges by migrant workers, which you say in the guidelines are equivalent to debt bondage. So I wonder if you could comment about this, again, case example showing that there are gross violations of human rights associated. And finally, John, can I just echo what you said about European ratification? I would say with greatest respect for Marco and my strong support for the way that the EU works together on these issues, you know, there aren't other ILO conventions where we would say they shouldn't be ratified because they're controversial. Once they're agreed, you know, our job is then to get them ratified. And to Austria, Croatia, Cyprus, Denmark, Estonia, France, Germany, Greece, Ireland, Latvia, Luxembourg, Malta, Poland, Romania, Slovakia, Slovenia, Sweden, and my own country, the United Kingdom, surely they should be the countries should answer why only 11 out of 28 EU countries have ratified this. We shouldn't be making excuses for non-ratification, and I really welcome the point made by the Employers' Federation. They're saying we should do it. Why should we say we shouldn't?
If there are any of those member states in the room, I would encourage them to reply. I'll just take these two, and then we will have plenty of time for at least another 1 or 2 rounds of questions, but we'll just take these two now. Anne?
Thank you very much. Yes, my name's Anne Lindsay from the Catholic Agency for Overseas Development. Sorry to turn away from the panel, but just to make sure that for the microphone it's clear. I wanted to thank you very much for really kicking off a helpful debate and discussion. And there are 3 points I really wanted to flag up, also with a slight bit of controversy since John is concerned about too much agreement on the panel. Maybe to start off with, thank you very much for the presentations highlighting this key challenge for us in terms of the power imbalance faced by these workers and explaining why these forms of employment are very closely linked to high risks of abuses of key human rights. For example, in terms of a safe working environment, the ability to speak up about problems or discrimination, or to be able to join a union. And I guess my apple of discord was, it's a great panel, but maybe it would also be good to have one of the user companies on the panel, because it does seem that the real challenge is this nexus between the use of agencies and, in particular, I'm thinking of multinational companies, where it's part of a deliberate strategy by companies in terms of reducing costs within their supply chain and can, in some cases, be integral to their business model. And I just wonder how much we're really getting to the grips of that business model and that relationship here, and how can we address those challenges. Secondly, I think it was great to hear about the call for regulation, because I certainly would agree with the points that we need the right framework in place. And I guess I'd highlight that as well as progress on ratification of specific conventions, there's action that we can take now in the European Union, which is currently looking at what large companies need to report in relation to respect for human rights. And CAFOD would say this is an opportunity for supply chain business relationships to be explicitly mentioned in terms of reporting requirements on human rights risks and impacts. And then finally, I think just a reflection for this group, but also for the forum as a whole. I think we're here specifically to think about the guiding principles and the impact that they're having. A lot of the problems that were so eloquently sketched out are not new in relation to supply chain workers. So I'd be really keen to get thoughts from the panel on how can we see whether the guiding principles are driving any kind of change for workers on the ground recruited via agencies, and what can we do in future to measure impacts or lack of impacts more systematically. Thank you.
Thank you, and thanks for a very great sort of final question there that I think all panelists should try and respond to. And gentlemen, you'll be the last of this first round.
Ladies and gentlemen, I represent the Ukrainian Independent Maritime Trade Union. We unite some thousand of Ukrainian seafarers, and I propose to panelists to connect the recruitment and entities problem, the problem of guiding principles, and the seafarers' work problem. Today, the seafarer's job is the most important for the world trade. For example, Ukraine is a country that gives to the world trade fleet more officers than any other one. So it makes our economy dependent from global market, and it makes global market dependent from our economy. And all the maritime labor is dependent with employment and recruitment agencies. And if you analyze the practice in this area, when we point on LEX and the guiding principles is a good tool for probably decisions on such negative phenomena as corruption, as low demands to recruiting personnel in maritime area, as no responsibility for recruited person from employment agencies, lacks and gaps in collective bargaining processes, and all these problems, in theory, were decided by the Maritime Labour Convention that was adopted in 2006. A lot of countries ratified this convention. Now it is in force. But if you analyze the practice, then we will see two tendencies. First, the countries who ratify this convention do not implement its standard to national legislation. We have connections with European seafarers, and we know that in Deutschland, in Bulgaria, in Romania, in Croatia, and other countries that ratify this convention, there are no practical mechanism of implementation its demands. And we have our problem, we have no ratified, Ukraine did not ratify this convention at all. So one of the most biggest countries of recruiting and employment and working in global seafarers market did not implement this convention, and these demands are not duty for us. So this problem, the problem of guiding principles and MLC 2006 is a huge problem. I propose to discuss it. I propose to connect mechanism inter alia for this sector guide, employment and recruitment agencies guiding principles. So also I propose to enforce the cooperation between UN and ILO in these positions, and to enforce the control from the UN bodies to the activities of association of workers and business in the maritime labor sector. Thank you.
Thank you very much, and thank you to provide a trade union perspective, which we hadn't had up until that point. Can we come back to the panel? Panelists first, and then the two respondents. So maybe Juliette, do you want to go first?
Yeah, I just wanted to make some general comments which probably respond to several of the different questions or angles that have been brought forward. First of all, of course, the types of abuses that we see in this area do affect developed countries, countries from the EU and rich Gulf countries, for instance. And our work has really shown what kind of problems migrant workers are facing in these countries. But the violations take place at every step of the process, and they need to be addressed at every step of the process, not just in the place where these migrant workers end up, but at the very start of the recruitment in terms of prevention. And I just wanted to make the comment generally that I think for many of you it's no surprise that Human Rights Watch finds that the guiding principles are insufficient in themselves. They're an insufficient approach to really deal with these problems, because we really think that binding norms are what is needed to really force compliance and force protection in these areas. For us, of course, there has been some step forwards, particularly where there has been buy-in by many companies, by many industries, and many businesses who have a bona fide commitment to human rights have made the efforts. But the problem, essentially, of the guiding principles is that it doesn't deal properly with those that are engaged in irresponsible action and that willfully abuse rights. And the enforcement paradigm within the guiding principles doesn't go far enough in providing sanctions and penalties for those that abuse rights. And that's our main concern. So, we will maintain that regulation is necessary and binding regulation is necessary, and that the best way to promote change is to enforce penalties when there is abuse. And many governments are not doing this, so we can't just rely on governments. Our work has exposed a lot of abuse in many places, and it's the exposure of the abuse, it's the sanction that comes with it that has also started to promote change in some of those places. But there has to be very concrete sanctions for those that are abusing the rights.
First, the 27 ratifications, and the representative of the EU said that that's not a lot. But generally, if you look at the ratifications of conventions the last 20 years, that has been less and less. So the popularity of ILO conventions is not growing generally. And if you look then at Convention 181, it's belonging to it's ranking number 4 if you look at the ratifications of the last 20 conventions since 1990. So you can't say that this is not a popular instrument, because if you look at relatively, it's quite popular among the older conventions. The ILO did a survey in 2010 and asked a survey about employment instruments, and the outcome of that survey was that there are, apart from the 27 we have now, that there are around 40 prospects. So on the question of the ILO, do you want to ratify this convention in the future, there were 40 countries who said this is what we want in the future. And there were also countries which said this is what we don't want, and then you see the most the obstacle which occurs is the no charge fees to workers, because that's what you see. Even you see that in the United States, you see that in India, you see that in Nepal. So there are still a lot of countries who are not against that, and that's a principle. What you hear, that's a principle in Europe. That's a principle what we are promoting as well. But there are still a lot of countries which don't want to share on that aspect. So that's what, and then lastly, why are governments not ratifying it generally, and why don't they make more speed? That's what you have to ask the governments as well. But generally spoken, if you look at legislation, especially in Europe, you see often that it is along the lines of Convention 181. If you look, for instance, at Sweden, they have not ratified it, but in the Swedish law is nearly according to 181. If you look at France, for instance, the supervisory machine of the ILO has asked France to report this year back, because France is not in line with the Convention 181 and with the convention they have ratified at the moment, because they have still ratified 96, Section 2. So France has to forbid agencies while they have a very elaborative legislation in this field. So France will have to come to ratify it. So, yeah? Okay.
Well, yeah. Well, unless I don't want to cut you off immediately. You got a little bit.
The question about the seafarers from Ukraine, maybe what I know is you said that Ukraine has not ratified the Maritime Convention. Yeah, then you have to ask your government, because the Maritime Convention is the most popular convention of the last years. If I speak about Convention 181 ranking number 4, the Maritime Convention is ranking number 1. So it's among governments very popular. There is a whole promotion campaign to get this more ratified. There are, in the meantime, more than 60 countries which have ratified that. But then you see ratification is not the only case. You have to implement it as well, and you have to create also enhancements. And that brings me to the migrant workers and the cross-border. If you see in Qatar that they have made bilateral agreements with all kinds of countries, but you need to have a supervision machine also to see if the enhancements is properly regulated. Okay, thank you.
Thank you. No, just when I do this, it means getting close to the end. It doesn't mean you have to just stop a bangle. Because that, you gave very good responses to all the questions. Nick.
Yeah, a lot of really good points. And as Fred, you were saying at the end there, you know, you can ratify things as governments, you can get bilateral agreements, you can get companies developing great CSR programs and saying we're going to implement these, we're going to follow these guiding principles, but it's actually only as good as what you put behind it to back it up. There are plenty of companies that have signed up and countries that have signed up to this, and the fact of the matter is the recruitment process, and coming back to what Juliette was saying in terms of the abuse that happens throughout the process, you know, I come from a point of expertise, if you like, at the point of recruitment. What we see in all the countries where we've ever operated, Kenya, India, Nepal, Philippines, these are all countries that export huge amounts of labour every year, is that the traditional model is, as I said in my speech, is charging fees to candidates. That is the commercial model. There isn't another model that exists effectively. So what do you do as a company or as a government to actually go out there into the marketplace and say, well, hang on a second, what we're saying is that this is not a model that can persist anymore, and actually you need to make sure that fees aren't being charged to candidates. Well, that means you need to get real experts that can go in there, do asymmetric auditing, getting under the skin of it, pull away the curtain that's being pulled over everyone's eyes and say, well, what is actually really happening? And that takes money, it takes understanding, it takes all those sort of areas of expertise and real commitment, not only from the governments in terms of pursuing businesses and getting under the skin of it, but also from companies shouldering the burden of responsibility to say, yeah, you know what, I'm really going to get to the bottom of what is actually going on in my labour supply chain, as opposed to just checking the box to say, yeah, we asked them, nobody's paying any fees. So it's about putting some real substance behind things.
Thank you. So Rachel, Felipe, some brief responses. Rachel, do you want to go first? Because you're here, and then... Oh, do you want to go first? No. I was just kind of... And then... Yeah.
Thanks. Two quick responses. One to Richard. Absolutely. In the work that we did jointly with the Institute for Human Rights and Business in researching the sector guides, this issue of immigration status tied to employment became, or tied to particular employer, emerged as a critical issue. It's one that others have highlighted. It's a classic example of policy incoherence. Because you have the branches of the state that are dealing with immigration on the one hand and business and trade. Those two are usually fairly well joined up and talking to one another. And then you have the Human Rights Agency or sector off on the side and not being involved in those conversations at all. So it's certainly something where we want to see states doing a better job there. Just to add to that, and actually in response to Juliette's point, the guiding principles expect states to review their legislation and to address relevant gaps, right, in this area, in other areas. And as states are developing national action plans on the guiding principles or taking other steps, if they're not looking at legislation as an option, amongst others, if they're not looking to develop a smart mix of measures, then they're really not implementing the guiding principles. So just to be very clear that it's a key part of the guiding principles. And then briefly in response to Anne, your question about, absolutely Anne, about this relationship between the user enterprise and agencies and who holds the power. We saw some interesting examples of leverage, the kinds of leverage that might be possible. First, some of the obvious ones around, well, how much business does the agency represent for the enterprise? How essential are they? That can give them a lot of power. Also looking at how you build this into terms of agreement in a more structured way. So there are some interesting examples of agency associations in some countries developing model agreements with their state clients, right, state employers. The potential for that to also be applied to other clients, to private sector clients, is interesting to explore. And finally, we had some great examples of agencies making the business case, right, as FSI and others are doing, but even very small Polish agencies that were involved in the guidance process who were really working hard to use whatever leverage they had to make the business case to their business partners. So I think there are some potential approaches.
I'd like to emphasize the point that Anne made about the impossibility for workers to speak up and the relationship that exists with all these that we've been debating, the need of ratification of the conventions. So I'd like to give an example of this difficulty. General difficulty. In Mexico signed and ratified the Convention of Freedom of Trade Union, but we are a country in which 98% of trade unions are white or apparent. With this challenge, we have a lack of representation as workers, real and legitimate representation. Besides that, the strategy that was mentioned by Anne, the policies of cost reduction by companies, seems to be nowadays a big interest for the Mexican government. For this reason, there is a whole system that's hindering workers from defending their rights. With this example, we can see that beyond the frameworks, we need other ways to make remediation accessible for workers. And that many times this should be a will of the states and companies to be applied. Thank you.
Okay, thank you. We have 10 minutes. So the challenge to all of you is to keep them short, and if you keep them very short and to the point, then everybody else can be pleased. I'm going to start with the gentleman on the left because we've neglected the left of the room, and then the lady in the middle, and then we'll move to this side. So, yes, sir, please.
Thank you, Mr. Chairman, and I also thank the panelists for their valuable contribution to this topic. I'm Nazrul Islam from Bangladesh Permanent Mission. So probably all of you are aware that we have a large expatriate worker community, and their stories are full of hardship and misfortune. But I see that today's topic includes implementation of even guiding principle in the employment and recruitment sector. So I assume that you cannot separate this employment and recruitment sector, though in our case it is employment is taking in one place and recruitment is taking place in another place, but the nexus of exploitation is so well founded in both the places that we have to keep this thing together. So actually we have talked a lot of multi-stakeholder approaches that like making migrant workers aware of their rights, but our experience is that I will agree with a lot of panelists that we need more regulations and we need a lot of enforcement from the states, because ultimately it is the states who matters. So if we have a lot of enforcement from the states, which will make way for access to remedy, either judicial or administrative, this is the only way where you can ensure the interest of the migrant workers. Thank you.
Thank you very much. Lady at the back there.
Thank you. I'm Sri Palupi from Indonesia, from Institute for Ecosoc Rights. I want to respond to the statement by Human Rights Watch that the MOU between Indonesia and Malaysia as a best practice in the employment and recruitment sector. Indonesia as a sending country have big problems in the employment and recruitment sectors. Almost 80% of the problem faced by Indonesian migrant workers is rooted in the sectors. The Indonesian government left the protection of migrant workers to the private sector or recruitment employment companies. The Indonesia law and Malaysia law on migrant workers, especially on domestic workers, tend to legalize the trafficking. It is caused that the MOU between Indonesia and Malaysia is not effective. Besides that, Malaysia do not follow the provision of the MOU, and Indonesia is weak in monitoring it and enforcing the law. There are still human rights abuse faced by Indonesian workers in Malaysia. For example, in 2008, according to the Indonesian government data, there were 513 Indonesian migrant workers who died in Malaysia without any effort from Indonesia and Malaysia to investigate the cause of their death. The MOU is not enough to protect migrant workers. We need a bilateral agreement that is binding on the sending and destination countries.
Okay, I need to ask you to wrap up so that everyone else can come in.
Okay, that is enough. Thank you.
Thank you. Thank you very much. Right, sir.
Thank you, Chair, for giving this opportunity. My name is Anand Kumar. I'm representing National Campaign on Dalit Human Rights. The issue that I want to flag is on the issue of the caste-based discrimination that widely present in India and the South Asia region. And because of the caste problem, the discrimination in the recruitment and employment is widely prevalent. And this includes based on the perception of the purity and pollution, therefore certain low level of work being assigned to the Dalit communities, whereas in the mainstream employment, there's a lot of discrimination is taking place. A recent study done by the Indian Institute of Dalit Studies found that by active disclosure of the identity, such as caste and ethnicity, excludes the people from the recruitment, the choice of getting shortlisted for the interview, and this has been widely quoted. So, but apart from that, the government of India has a mandatory policy of reservation in the public recruitment, which is a very good practices. Unfortunately, the same practice is not there in the private sector, where majority of the employments are available. But in spite of this, when the government of India called the private sector to promote the inclusion of the scheduled caste, that means Dalits and tribals in the private recruitment, the private companies said they will do it voluntarily through the affirmative action. But recent study found that there is a huge gap and lack of implementation of that. Therefore, my question to the panel, especially to the chair, how do we address the issues of social exclusion that is affecting more than 260 million Dalits in the South Asia region, whether the UN guiding principles have any solution to offer? Thank you.
Maybe the gentleman across, and then maybe if there's time for one more, yes.
Hello, my name is Lara White. I'm representing the International Organization for Migration. And first, I'd like to applaud the efforts of all of the panelists and the organizations that they represent, in addition to the ILO and governments in the efforts to both raise awareness regarding the issue of unethical recruitment and also to encourage the regulation of recruitment agencies. We have found that this issue has been raised to increasing prominence over the last couple of years, and we really applaud the efforts that are made by all of you in supporting this. From IOM's perspective, we have concerns that the regulation of recruitment agencies isn't happening quickly enough, And we're seeking to pursue innovative approaches to tackling the issue, which would include creating a space where employers can meet like-minded and trustworthy interlocutors, and where ethical recruiters can be recognized for their commitment to the ideals of Convention 181 and ethical recruitment. So I just wanted to let you know that we're working on this and developing a private-public alliance for fair and ethical recruitment.
Okay. Hi, David Wofford. I'm with the small women-owned business called Meridian Group International. We do health and workplace health in developing countries. And by background, we think health and reproductive rights are way underappreciated and discussed in this whole forum in the human rights world. But question on the gender aspects. Clearly, women workers have a specific set of issues, and I would love the panel to discuss how they see gender being addressed within this. It's beyond just grievance processes, but understanding the different roles of power among genders in recruitment.
Right. I'm going to give the panel an impossible task. You have 30 seconds each. Yeah? Can we start at this end?
It is now 11:45 and interpretation has now finished. Thank you.
Well, thank you. Well, solo quiero comentar algo respecto a lo que decía de cómo se tratan las cuestiones de género en este sector. En particular, en el caso de México, sigue siendo un gran problema por las relaciones de poder entre hombres y mujeres. El grueso de las personas contratadas en este sector son mujeres, por lo regular madres solteras y con muchos dependientes económicos, lo que las pone todavía en una desventaja mayor respecto a los supervisores y la gente de poder, que por lo regular son hombres. Muchas gracias.
Just on the gender question, just to say that most of our research on these issues has been done by our Women's Rights Division. So if you look into our reports, you'll be able to look in more depth at all these issues that you raised. And just on Indonesia, I'm sorry if my point came through wrong. The point I was trying to make is exactly what you said, that even the things that are cited to us as good practices are actually not good practices, because these types of agreements do not replace the change in national laws and the change in national enforcement mechanisms. These agreements do not solve the abuses that we're recording. So thank you for bringing that up, because we wanted to show that, in fact, even in the realm of good practices, that the examples are not satisfactory, and a lot more needs to be done in this area.
Thank you.
Okay. Yeah, I have only one. Yeah, it works. I have only one conclusion. That is, if you look at the 27 countries which have ratified 181, there are a lot of Western European countries among them. And what we don't have till now, that is a country which has used 181 to regulate cross-border staffing. And I think we have to give a priority to create a best practice to use the tool 181 to work out the cross-border staffing, and that's what I hope that we will get soon.
Thank you for being very clear. Yes, Nick.
I think it comes down both for government and business an understanding of the real grassroots issues. Great high-level dialogues, policies, ratifications, etc. Understand what is happening, what the realities in the source countries are, and how they're operating, government and business. Strengthening of international institutional mechanisms, cross-border true policy coherence.
Good, great. Final word, Rachel.
So just to respond both to the question about gender and the comment from our Dalit colleague, both of which go to discrimination. Yes, individual responsible agencies can take steps to address this, but where it's broader or socially tolerated, then it's something that the state has to be involved with. So next year, I would want to see states on this panel.
Mm. Yeah, there's an invitation to states for next year. We want you all up here. Thank you to a great audience. We've had a great panel, please, and thank you to the interpreters. Show your appreciation. Thank you. We didn't.
Sorry, thank you.